Thank you. And thank you for having us today. We really appreciate it. We're excited to be here. So, we're going to do a special education law overview. Prefacing that with we know there's a lot going on right now, a lot up in the air. So if there are we'll have a Q&A portion at the end. Right now, we're really going to go with what is advertised as special education law overview, and we'll weave in some current information as we can throughout the presentation. There we go. So we always give this disclaimer that the presentation is for educational purposes only. It is not intended to be legal advice or a substitute for legal consultation and counseling. So, I know a lot of people on this webinar might have specific situations that they have questions about or they're concerned about. We definitely advise, if you do, to reach out to kind of an attorney first, especially specifically for your state. That being said, we hope this is helpful information. So where are we heading today? We are going to talk about what is special education generally. Then we'll move on to the evaluation and eligibility processes. We've carved those out into two separate sections, even though they kind of go hand in hand. We'll talk a little bit about extended school year services and transition planning, dispute resolution, which is always a fun one, and then some notes about school approaches to challenging behaviors. And then at the end, we'll also cover some resources. So first, back to kind of the basics, what are the relevant laws? We're going to be speaking today mostly about the Individuals with Disabilities Education Act, which governs individualized education programs, or IEPs. We're going to focus on IEPs rather than individualized family service plans, which are IFSPs, which are for those younger children before they enter the school setting. We'll give a little info about IFSPs, so we don't want to totally ignore that those exist, but it's a lot to pack into 1 hour. And then we're not going to cover Section 504 of the Rehabilitation Act today, but we also just do like to note that Section 504 governs Section 504 plans, and we include some resources as well. We're going to focus on federal law today. We'll note some areas where we know there's state distinctions, but again, it's really important, specific to your state, if you're looking at a specific question or topic, to kind of look to see if there's any differences for your specific state. So first off, what is special education? So the IDEA provides children birth through 21 with disabilities access to a free appropriate public education, also called a FAPE, F-A-P-E, through two types of documents, as I kind of discussed before. So those IFSPs, which govern young children, birth through age 2. A few states, including Maryland, have an extended IFSP option that can kind of take a student up to their 5th birthday, so up to their kindergarten year. But most states do not have that extended option. And then individualized education programs, or IEPs, are for children and young adults 3 to 21 years of age. So briefly, an IFSP is a written plan that focuses on the child and family. So one of the key differences for the IFSP is that it also focuses on services to the family, not just the young child, to enhance the child's development. Again, this is generally birth through 2, and services are provided in the child's natural environment. So that could be the home, a Head Start program, a daycare, a preschool, etc. IFSPs include some similar things to IEPs. So what are the child's current levels of functioning, services that are to be provided. Some differences are that it really includes family information. IEPs include parental concerns, but IFSPs include broader family information as well. Results or outcomes expected to be achieved by the child and the family. So again, we're looking at that family focus and when and where the services will be provided. So back to what setting, whatever natural setting the child is in throughout their day. An IEP, so again, for students who are older, 3 through 21, depending on your state, students can start an IEP a little bit older if it's an extended IFSP state. a document that describes the special education and related services that the child is entitled to receive. And we'll talk about eligibility in a couple of sections. Um, Again, the eligible child with a disability has a right to a FAPE provided in what is called the least restrictive environment. We'll also cover what is the least restrictive environment and what are the legal requirements around that. Special education is specially designed instruction to meet a child's unique needs. And the focus is on allowing the student to access the general education curriculum. And so we really always focus in our advocacy efforts around the child's unique needs. So what does that specific child need to be successful in the school setting? So typically, a lot of people on this webinar have probably heard schools say, well, we can't do that, or we don't have the staffing. And I think it always is helpful really to bring it back to that specific child's needs. And special education also includes related services, which are things such as specialized transportation services, speech and language, occupational therapy, physical therapy, some of those other things that a student might need to be able to access their education. And I'm moving fairly quickly. We have a lot of content to cover, but if people have questions and they're kind of relevant to the specific content, I'm always happy to, if you put them in the webinar chat, I'm always happy to kind of try to weave them in as we're going through this. And if not, we can discuss at the end. So the first question is, who decides if a child with a disability needs help? So, as a family or as a person with a disability, you may have gone and received a medical evaluation from an outside provider and received a diagnosis. And so for people who are school age, the IEP team determines eligibility for school services. So for that IEP. Members include, parents, students, general education teachers, special education teachers, service providers, so those related service providers, school administrators. Whoops. There we go. We're back. And so there are required members of the team, and then families can also invite other people with specialized knowledge of a student. So, that could be an attorney or advocate, that could be a family member, that could be a medical provider. So there's all sorts of different people who can be involved, and it really is important to have people who, know the student well. The student especially, typically can provide input on what they think they need in terms of services and assistance. And so Kendall is going to take over here for the evaluation process.
Great, thank you, Mallory. So the evaluation process. So it starts with a referral to for an IEP. So children are first referred by either their parents, the school, or the local education agency. The referral should be made in writing. The referral should be dated, and the parent should make sure they keep a copy of this referral. Next slide. So the initial evaluation must be completed within 60 days that the parent gives their consent for the evaluation, or 90 days from the initial referral, whichever happens sooner. So this includes a meeting with the IEP team, determining if formal assessments are needed, completion of those assessments, and then a follow-up meeting with the IEP team to review those assessments and discuss eligibility. So for assessments, assessments are ordered in all areas of the suspected disability. The parent must provide written consent for these assessments, and they must be performed and explained by a professional. So if a parent disagrees with the assessment results, they can request an independent educational evaluation, also known as an IEE, by someone outside of the school system. So this can happen one of two ways. So the school can either agree to pay for it, or if the school system refuses, they must put the reason in writing and then file a due process hearing to show that their evaluation is appropriate for that student. Just a note about outside assessments, IEP teams are required to consider them, but they are not required to accept them. So we get that a lot, just making sure that that's something you're keeping in the back of your mind.
And I just like to note that this can be really frustrating for families. So we work at Kennedy Krieger, families will wait, a long time to come and get, for example, a comprehensive neuropsychological evaluation. The psychologist will make lots of great recommendations for both, the home setting, the community setting, and the school setting. And families will take those recommendations back to the school setting. And, as long as the IEP team reviews that report and considers those recommendations, that's all they're legally obligated to do. So they're not obligated to accept those recommendations. So if the report, for example, recommends a specific accommodation or service, the school team, the IEP team can say that's great, but based on our school-based judgment, we're not going to do that, and here's why. So I just like to note that because I know that can be very frustrating.
So some tips for the evaluation process, keep a copy of the letter requesting an evaluation and the consent for evaluation form, keeping a calendar or a timeline for the evaluation process, complete all rating scales requested by the school system, keep a copy of the assessment reports, whether that's in a binder, folder. If you have outside evaluations, you may wish to share them with the IEP team, and then provide written consent to the initiation of services if you agree with the proposed IEP. And now Mallory will discuss eligibility.
Perfect, thanks. Sorry, my slide progression is a little bit on the fritz here, so I apologize for any kind of funky delays. Um, so for eligibility, so the legal definition, right? A student with a qualifying disability who, because of that impairment, needs special education and related services. And so these are the qualifying disabilities under the IDEA. Developmental delay is a little bit of a catch-all for students ages 3 through 7. And then these are the others. We're sending the slides out, so I'm not going to read every single one through, but just to give an idea. And I always like to highlight educational disability versus medical diagnosis. And so a student may have a medical diagnosis of, for example, autism, but they may not meet the eligibility requirements for an IEP. And this can be for any medical diagnosis. So a student might have a medical diagnosis of ADHD, but may not meet those eligibility requirements. The team, as a part of that eligibility process, I always think of it as a three-parter. So the first is that educational disability, which is usually determined via psychological testing, educational testing, potentially, speech and language, other types of assessment via the IEP team orders. But there also needs to be educational impact and a need for special education and related services. So if a student has a medical diagnosis, but there is no educational impact in the school setting, then they likely will not be eligible for special education and related services. So they won't be eligible for an IEP. And so I just always like to make that kind of note that it doesn't mean that that student might not have an educational impact in the future, or that they aren't eligible for a Section 504 plan, which would look more at providing accommodations, but at that time they wouldn't be eligible. If a student is found to be eligible, so they've gone through the evaluation process, they meet at that, they have an IEP meeting to discuss eligibility and determine that, yes, the student is eligible. Within 30 days, the IEP team must meet to develop an IEP. The local education agency must implement the IEP as soon as possible after the meeting. And IEP teams must meet at least once a year to review the child's progress and revise the IEP. That's called the annual review meeting. It doesn't mean the team can't meet more, especially if the child is not making progress towards their goals and objectives, or goals depending on your state. Not all states have objectives. But there needs to be at least one meeting per year. So an IEP includes present levels of academic achievement and functional performance. So that really is looking at different data points. So, teacher input, formal assessment, informal assessment, grades, statewide kind of district assessments, all sorts of different things to look at where is this student performing. And I always like school teams to tie, especially for academics, right? Tie the performance to a specific grade level performance. So maybe the student is in the fourth grade, but performing in math calculation at the first grade level, just so that year to year you can really track that student's progress. And one thing I always look for in present levels is that there are actual data points and numbers, because it's really hard to track progress based on more general statements. Annual goals, and then as I kind of alluded to before, some states have short-term objectives. Maryland does. So that's another thing that's important to look at for your specific state. But those goals should be measurable and they should be tied to areas of academic need. And so if, for example, that student who is performing on the, at the first grade level in math calculation, but is in the fourth grade, then we would want to look at what specific skill gaps does this student have. And oftentimes here in Maryland, we look at both what skills is the student going to need to learn to access the fourth grade curriculum, and we write around a goal around that. And then we also write a goal looking at that skill gap, so looking more at that first grade level, what skills do they need to learn to kind of be caught up to that fourth grade level. Related services, so again, we would be looking at the type of related services, so speech and language services, how often and how long those are happening. So, is it 30 minutes one time a week? Is it 60 minutes once a week? So kind of looking at that and making sure that's spelled out. In addition, supplementary aids, services, accommodations, modifications, and programmatic supports. That's a long way to say other supports that the student is going to need in the classroom to be successful. So that could be, extended time, that could be copies of notes, and really looking at where is that student struggling and what do they need as an individual student to be successful. Educational placement. So this is one of the really big things we get calls about, where families are frustrated about the student's current placement. They don't feel like it's the appropriate fit. And so the IEP team determines where the student will receive special education and related services. And I'll go over the list of placements on the types of placements on the next slide. And school systems are legally obligated to provide a variety of placement options. Here in Maryland, we have a lot of variation across, we're a small state, but a lot of variation across our state in terms of urban, suburban, and rural. And so the central part of our state is more kind of urban and heavily populated suburban, Baltimore, Washington, D.C. And so those school districts typically have kind of a wider variety of placement options. Our more rural school districts, and so the Eastern Shore, the Western Maryland, kind of, they're more mountainous on the west, kind of more farming on the east. Typically don't have as many placement options. They're much smaller areas, smaller school districts. And so it can be really tricky if you have a student who has pretty, kind of a higher level of support needs and you're in one of those areas. So that's just to acknowledge that, on paper, right, school systems are supposed to have a variety of placement options. It doesn't always happen in practice, and you have to really work to get creative in those situations if the student's needs can't be met in their local public school. So if the school system cannot find an appropriate public placement, then the school system has to pay for what is called a private separate day school or a non-public school. It's kind of the other wording used to describe that. And that is a school that is it focuses on educating students with disabilities, but there is no access to typically developing peers. And so for educational placement options, school systems are again obligated to educate students in the least restrictive environment that is appropriate for that student. And so we kind of think of this as along the continuum. So the least restrictive would be a general education classroom in the child's neighborhood school. So if you look at what the school that the other students in the neighborhood are attending, that would typically be the neighborhood school. If where you live has charter schools or something like that, that would also be considered the child's air quote neighborhood school, even though it's a charter. Um, Access to a resource room or more than half a day in a resource room in that neighborhood school. A self-contained class in a comprehensive school. So that might be a specialized program for students with disabilities that is in a comprehensive school. So a school that educates the students from that neighborhood, but the regional program might be in a specific school and not housed in the student's neighborhood school. So they might be going to a neighboring school that has some additional resources. You can also have a self-contained class in a public separate day school, and that is a public school that is only serving students with IEPs. And so there is typically no access to typically developing peers in that public separate day school, unless it's partnered with a public school. We have a couple public separate day schools here in Maryland that I can think of that are on the same campus as a public school. And so the students at the public separate day school are able to participate in activities with these students at the neighboring public school. So again, public separate day schools and next the private separate day school that I described on the last slide, the non-public school, are highly restrictive settings, right? Students aren't, do not have access to typically developing peers. And so most school systems weigh that pretty heavily in kind of talking about those placement options. A residential facility, so that is where the student would live and attend school. So they are there 24/7. And then home and hospital instruction. And home and hospital is actually the most restrictive on the continuum because students don't have any peer access, whether it's peers with or without disabilities. And you can also do a combination of these options. So some tips for IEP development. For parents, I think it's really helpful to have somebody else who is there with you at the meeting, whether it's a partner, friend, spouse, advocate, attorney, whomever, just to be able to help take notes and be, it's really hard to be there. There's a team of a bunch of other people, right, who are all typically from the school side. And while everyone is equal participants of the team, we commonly hear from parents and family members that I don't feel like I'm heard. I don't feel like I'm an equal participant. So having someone else there with you and also to have them take notes can be helpful. If you don't understand something that someone's recommending, or if someone's reviewing a report and you feel like this is a bunch of numbers and I have no idea what they're actually this means and what they're telling me, always stop and ask. The team is really there to help explain things. You want to make sure that you're understanding the information that the team is using to make decisions. Again, taking notes during the meeting. You can also ask to record the meeting if you feel that you want to listen to it later, or be able to share the information with a service provider, or you might feel that the IEP team, the prior written notice that comes home, that team summary, doesn't always capture everything, and so you want to have a record of what was said. You should definitely provide advance notice, since the school will also likely want to use their own equipment to record the meeting. And it's really important that if you are recording, to let the school team know, especially, for example, Maryland, we're a two-party consent state. So everybody who's being recorded has to consent to being recorded. If not, there's some legal issues that come from that. Requesting a break during the meeting if you need it. IEP meetings can be very long, they can be emotional, they can be stressful. And so if you feel that you need to step away for a minute, whether it's in person or you're on Zoom or Teams and you need to just kind of go off camera, stretch your legs, take a break, that's completely fine. And trying to remain calm, although I know sometimes that, that can be difficult. All right, and Kendall is up for extended school year.
Yeah. All right, you can go to the next slide. So extended school year services, also known as ESY. So the IEP team must consider if a student's IEP has goals that are related to critical life skills. In addition to that, they must see if there's going to be regression, a degree of progress made, if there's an emerging life skill or breakthrough opportunities if they were to attend ESY, if there's interfering behaviors, the nature and severity of the disability, and then if there's any special circumstances the team should consider. So in addition to that, the team must also determine if the student's ability to make progress during the year is in jeopardy if they don't receive ESY. Some tips for ESY services. So the IEP team should hold a meeting before the end of the school year to determine eligibility for ESY. If the team does not schedule a meeting, you should request an IEP team meeting in writing to discuss ESY. Make sure you request the meeting so you have enough time to appeal the decision if it doesn't come back in your favor. So that way you can get it all done before ESY begins. And then ESY is determined every year. So every year you would have this same meeting to discuss ESY. Next up is transition planning. So transition planning and the law. So the IDEA indicates that all children with disabilities are entitled to transition services. This is also known as transition planning. Transition services are provided by the school to help students transition from high school to the adult world. Just a note about transition. So individuals who have a 504 plan are eligible for accommodations, but they're not entitled to transition planning services. Next slide. So what is transition planning? So transition planning is a process that brings students and their families together with school to help plan and prepare students to leave school and enter a post-secondary school environment. This can be an adult day program, employment, vocational school, or college. And it, excuse me, and it must begin by age 16 under federal law. However, in some states it starts earlier. So for example, in Maryland, it starts at age 14. Next slide. So with transition planning, there's a few options. So you can have a diploma, so high school diploma, certificate of completion, or general education diploma. And then, like I had said, the post-secondary options, the adult day program, employment, vocational program, or college. Next slide. So transition plans must be results-oriented, based on the individual, improve academic and functional skills, and help transition out of high school. So being results-oriented, this means that the goals for transition plans need to have specifics that can be measured. So determining whether the goals were achieved, being able to see, yes, okay, they are making progress on this goal. So for example, you can measure how many words you can read in a minute, but we can't measure if you read well. So based on the individual, so transition plans should be based on the individual student and take into account their unique abilities. It's important to consider the student's goals and interests as well when you're discussing transition planning. Improving academic and functional skills. So these goals should focus on academic skills like reading, writing, and math, but also focusing on functional skills that'll help them live as independently as possible. So this can be learning how to shower on their own or learning something towards a vocational skill. And then help transition out of high school. The goal of a transition plan is to make the transition process as smooth as possible and to help that student be as successful as possible out of high school. Next slide. Goals for a transition plan. So academic skills, so like I said, reading, written language, math, any type of academic area that would be part of their post-secondary plan. Communication skills, so like requesting, being able to follow and give directions, communicating information with others, social skills, so like answering a phone and being able to make calls, learning how to protect themselves from victimization, and then occupational and vocational skills. So being able to use a time card, arriving to work on time, using appropriate voice and tone and volume while at work. Next slide. So goals. So like I had said earlier, the goals must be measurable. And a measurable post-secondary goal is an outcome that occurs after the person has left high school. So the student will, not the student hopes to, plans to, or will investigate. And the path toward achieving the goal occurs before the student leaves high school. So they are actively working on this goal while they're in high school. Next slide. The IEPs. So IEPs with transition planning must include documentation of evidence of the age-appropriate transition assessment, appropriate measurable post-secondary goals, and whether that's in employment, education training, and independent living as appropriate. An annual IEP goal related to the student's transition services needed, transition services, courses of study that will reasonably enable the student to meet those post-secondary goals, and then evidence that the student was invited to the IEP meeting, the parent or student, if the student has reached majority, also the student, has provided consent for agency representatives to attend the meeting and be invited, and that the agency representative was invited to that meeting. Next slide. And Mallory will be discussing resolving disputes.
Sorry about that. My boxes disappear since I'm screen sharing, so it takes a minute for them to pop back up. And I saw in the chat, I was kind of monitoring as things were coming in the Q&A. There are quite a few questions around dispute resolution, so I'm going to try to touch on those as I'm talking through this as well. So one thing that I like to highlight, and I feel like it doesn't always get the full appreciation it deserves, is the prior written notice document. I sound like a total nerd there. Now, the prior written notice document. And so after every IEP meeting, the IEP team should provide prior written notice. And it basically is provided before the public agency proposes or refuses to initiate or change the identification or evaluation of the student. And that's a wordy way of saying it really anything that the IEP team is really proposing to change. They should be documenting this in the prior written notice. So for example, if the team proposes that they're going to add or remove services, they should be documenting what they're proposing, why, and what the team agreed to. Same goes for parents. So if a parent proposes, for example, they believe that their child needs additional special education services outside the general education setting, the school, the rest of the IEP team, the school-based team disagrees, that disagreement should also be documented in this prior written notice. And as a parent or family member, if you're asking the school team for something during a meeting and they're saying no, or it's really important, and all you have to do is say, please document this please document my disagreement with this decision in the prior written notice is really all that you need to say. And it's really important to have these things documented, because if you are going to move forward with more formal dispute resolution options, having the disagreement documented is very important. And so that's just a note, and really all you have to say is that, even if you're like, what the heck, what the heck is going on, just make sure that's documented, ask the team. And then after the IEP meeting, when documents are sent home, or if the team doesn't send them, making sure you get a copy of that prior written notice and that the information in that PWN is accurate. So we always look at, there's multiple ways to resolve disagreements. I always take the approach of least resistance first and then kind of work up from there. And so I always think it's good to first request an IEP meeting to discuss the concerns. And so, oftentimes families will come to us, retain an attorney, we'll go into an IEP meeting and the school team will say, we had no idea that these concerns existed, whether that's true or not, you don't always know, right? But it's always really important to discuss concerns. I always tell families, if you can write, in email, or a letter kind of summarizing what are your concerns, propose resolutions if you have any, and send that to the principal and or the IEP chair. And that way your concerns are also documented in writing. I think that's one of the most important things, is that just having a good paper trail. And so even if you have a phone conversation with somebody at the school, sending a follow-up email to say, hi, I really appreciate you taking the time to talk today. Based on our conversation, here's my impressions of what the next steps are going to be, or whatever the appropriate content for the email would be. But it's really helpful when families come to us, and they're looking for legal services, if there's that paper trail that we can go back and say, look, this family has really tried everything under the sun to resolve this issue, and it still hasn't been resolved or gotten the attention it needed. Um, if things aren't working out at the school level, typically the next step is to contact the Office of Special Education for your local education agency. And Office of Special Education, I know different school districts across the country call them different things, but it's where your local director of special education is housed typically. And then local education agencies, same thing, right? Different school districts are called different things. We just use LEA in this presentation just for kind of consistency. And so reaching out to your director of special education, again, in writing, and saying, hi, I've tried to work with the school team to resolve my concerns about this situation. Here's what's going on. If you have that paper trail of those emails, right, sending those with the contact to say, look, this is the communication around this. If that still doesn't work, then there are a few different options. One, which I have a slide dedicated to next, so I'm just going to note it, and then we'll talk more in more detail, is filing what's called a complaint. Typically in Maryland, we call it a state complaint. So it's a complaint with our state Department of Education, where they will investigate the allegations. It's written. Filing request for mediation in writing, and so that's an informal meeting. It feels formal because it's here in Maryland. It's in front of an administrative law judge with an independent mediator. Everybody comes to the table, whether it's in person or virtual. So family will be there with any other person. Usually it's a school district representative, whether it's their director of special education, a compliance person, their attorney, somebody who kind of can speak on behalf of the school district, and hopefully offer some type of a solution that the parties can agree upon. One thing to note is that both parties must agree to mediate. And so we've had situations in our office where we have filed a request for mediation and either the school district declines because they know that they're not going to offer what we're asking for. And so they're not going to, spend their time sending their people to a mediation. Or they might agree to mediate, and then we've had school districts where they've agreed and then pulled it out at the last minute, which is really frustrating for families. But I do think mediation is typically a very helpful tool. It's it doesn't hurt to try. You don't have to come to an agreement at that mediation. So, if you don't agree, then you move on and then you kind of go from there. Um, Filing a request for a due process hearing, which is a more formal and expensive proceeding. It's in front of an administrative law judge. They have relaxed rules of evidence, but there are still, you're examining and cross-examining witnesses, you're, entering exhibits, all that type of stuff. And so we really do recommend that families, unless a parent has kind of extensive legal experience, families consult an attorney. We know that can be really expensive and those options aren't always available. And families do go pro se, so unrepresented, where they are going on their own. Here in Maryland, we've only had I've tracked our data since it's been disseminated by our State Department of Ed. That started in 2014. And we've only had one pro se parent win a due process hearing. Sometimes if you do file for a due process hearing, the case might settle ahead of time. So the school district attorney might look at it and say, yeah, these facts really aren't good for us, rather than spending our time and money going to hearing, we're just going to agree to what the family's asking for. And so that can happen. There's also a resolution session that's a part of that process. So it's kind of a last ditch effort before the due process hearing. It looks a little similar to mediation, and it really is to try to get the parties together to talk to see if they can come to a resolution before going to the hearing. Hearings can last anywhere from one day. We had one, typically there are a few days, I would say in Maryland, we're kind of in like the 3 to 8 day range is our typical hearing length. The days aren't always all in a row. And so families are having to take off of work, arrange childcare if they have a younger child who's home. It's really hard to win without an expert witness. And under federal law, expert witness fees aren't reimbursable in these cases. So there's a lot of barriers to families for accessing these due process hearings, but they do exist. And in Maryland, we're always trying to find ways to make these more accessible. So we passed state legislation, 2 legislative sessions ago around making expert witness fees reimbursable for families. And so if families are having to hire an outside psychologist, you really can't win without an expert witness in most situations. So if you're having to hire an outside psychologist to come in and testify on your child's behalf, if you win, those fees can be reimbursable. So I don't want to sound like a doomsday person here, but due process hearings are a great it's great that they exist, but they can be really taxing and expensive. Another type of, and I'm going to cover this briefly, for a disability discrimination claim, you can also file an Office for Civil Rights complaint that right now, as many of you on this webinar have probably been following, and we're not going to go too much into current events because we, again, don't have a lot of time, but, the staffing within Office of Civil Rights, or OCR, has been really functionally gutted. I think 8 of the 12 offices nationwide have been closed. The OCR complaint investigation times prior to this happening were already pretty lengthy, and so now functionally there's not going to be enough. It will not be enough OCR staffing probably to effectively investigate these complaints at all of anything close to a timely manner. And so just keeping that in mind, that it is an option. However, things are changing on a daily basis at this point. And there have been some lawsuits filed around this. The Council for Parent Attorneys and Advocates, which is a parents attorneys and advocates organization, filed a lawsuit in conjunction with another organization on behalf of 2 families. It's a class action lawsuit, basically arguing that the OCR complaint process is going to be made ineffective by the staffing cuts. So moving on to a state complaint. So I did see a question: what determines denial of FAPE, and what is the remedy? Can you ask for comp education as a remedy? So for mediation, it's really that the mediator is mediating the agreement. So the parents in the school system are really determining, no one's determining necessarily there was a denial of FAPE, but the family and school district are agreeing to comp ed as a remedy. So no one's saying, yes, there was absolutely denial of FAPE unless the school system's admitting to it. For a due process hearing, the administrative law judge is making that determination. So they are saying, yes, there was a denial of FAPE, or no, there was not. And you can ask for comp ed as a remedy. So that is one thing we commonly ask for. Comp ed is, and I do want to be mindful of time, so I'm going to try to wrap this up quickly. Compensatory education is where you are basically asking for services to make the student whole. So often it's tutoring, but it can be other things. For example, a summer program. And then for a state complaint, parents, advocates, and attorneys can file, so anyone can really file a written complaint that they believe a child's rights to a FAPE have been violated. Some states, Maryland included, only consider procedural violations. So that is that something was in the IEP, for example. So a student was supposed to receive 5 hours a week of specialized instruction. They didn't receive it. So, in the IEP, didn't receive it, procedural violation. Some other states will consider both procedural and substantive. So substantive would be more that question of are the services appropriate, right? And kind of those more gray area questions. The state's Department of Education will receive the written complaint and must complete its investigation within 60 calendar days, is what it's outlined under federal law. And that period can be extended if either the parent in the school system or if they agree to engage in mediation, or, for example, if a due process hearing is filed, then the state complaint is typically put on hold during the pendency of that. So for a state complaint, the state investigator will come in and determine yes or no, there was or was not a violation of FAPE. And then they actually kick it back to the IEP team typically to, perfect. I was just told that we've addressed a lot of the questions. I haven't seen them all, so good. So I can keep going a little bit. So it goes back to the IEP team who committed the violation in the first place, typically to determine whether there was harm to the student, and if so, then what the compensatory services will be. So state complaints are great in that the state comes back and says, yes, there's a violation here, but it's a little tricky because it'll come back to the school team, and the school team then says, was there any harm? So the student missed speech and language services for 3 sessions, but was there harm in missing those 3 sessions? And if so, what are the comp services? So yes, so all to say, state complaints can be, again, great tools, but it depends on your IEP team. Backwards here. Tips to resolving disagreements. So again, explaining the concern to the team and why you are concerned. So, examples and documentation always, in my lawyer brain, right, I always want documentation of everything. Checking in with your child service coordinator or IEP chair regularly, so they're not surprised by your concern, and so that you're getting regular updates and there's that open back and forth communication. Always participating in IEP meetings. And so I know sometimes they can be exhausting, they can be frustrating. Some schools are pretty rigid about scheduling, but schools are required to make sure that parents are included participants. And if a school team sends you notice for an IEP meeting on a specific date, and it doesn't work for your schedule, they do need to work with you to reschedule to a mutually agreeable, is what it says in the law, time and place. There are many parent support organizations specific to various states and local education agencies. So always looking to find what your parent support organization is, and then contacting an attorney or advocate if you think you need additional help. Even if you don't necessarily feel that you have the funds for a private attorney, many states have attorneys who work at various nonprofits who may be able to assist, or if not, someone may at least be able to give you some brief advice. All right, quickly, we're going to cover school approaches to challenging behavior. And so I always like to cover this because I see this happen a ton in our work. There are many unacceptable ways of managing student behavior. So these are things that if these are happening to you or your child or a child that it's an automatic red flag. So repeatedly suspending a student from school, a pattern of office referrals, or other extended time away from instruction. So for example, sending a student to whatever you want to call it, right? A calming room, a quiet room, a resource room, or something like that, where they're not necessarily supposed to be based on the services they're receiving. Extended restrictions in privileges. So that could be anything from saying a child can't go on a field trip because the school's worried about ability to keep them safe, that a parent has to come with them on a field trip for the child to be able to go, anything like that. informal or undocumented suspensions, so getting a phone call from the school to pick your child up without formal suspension paperwork because they're having a rough day or something like that. You always want that suspension paperwork, even though I know as a parent, right, the gut feeling is, I don't want my child to be suspended. Getting that suspension paperwork builds that documentation that whatever supports and services this child is receiving probably are not appropriate. Shorten school days. So, this is not for, medical purposes, right? If a student physically can't attend a full school day and that's modified, but this is, oh, well, their behavior really spikes in the afternoon. So we think they should just go home after lunch. Improper placement on home and hospital teaching. So placement because of school's inability to manage challenging behaviors. And repeatedly sending children home from school with a condition for return. So you have to get a threat or risk assessment, or you have to get a psychological evaluation and show that to the school for return. And that arguably, right, violates the free component of free appropriate public education, because oftentimes those are costing a family money. Strategies to address this type of concern, request in writing an IEP meeting. So, if the child's not eligible for special education and related services, to discuss eligibility, looking at updated assessments, particularly a functional behavior assessment, to get clarity on what might be underlying the behaviors. And if the student already has a behavior intervention plan, then consider whether it's addressing the current behaviors, and just document everything. So document calls home, request to pick your child up, communication about challenging behaviors, time missed from class, really anything. And that could be a whole separate presentation. Kendall is going to briefly cover resources.
Yep. Thank you. All right, next slide. We just wanted to touch briefly about Achieving a Better Life, also known as ABLE accounts. So ABLE accounts allow a person whose disability began before the age of 26 to contribute money to an account up to $100,000 to save money without that affecting most federally funded benefits based on need. So this money can be used for qualified disability expenses, which include education, food, housing, medical bills, transportation, and job training. Effective January 1st, 2026, the age of disability onset will be 46. So that's a big jump. And then here are a few resources for ABLE accounts if interested. Next slide. And these are just a few resources generally for kind of all areas of special education. So Center for Parent Information and Resources, Council of Parent Attorneys and Advocates, also known as COPA, IEDEA information for those who have IEPs, IFSPs, Project Teal resources, so about our organization, Section 504 information, and then Right the Law is a great resource that just has kind of all different areas and topics within special education and just brief knowledge, advice. There's like questions, answers, things like that.
And Copa, one of the questions in the chat was kind of, is there a good resource for keeping up to date on legal information in cases? Copa is a great resource. Their website, some of it's public facing, some you have to be a member, but they have some great resources around current litigation, kind of laws across the country, systemic issues that they're working on, things like that. And this is our contact information. You are always, anyone is always welcome to reach out to us. These are our email addresses. If you have kind of specific questions, even if you're not in the state of Maryland or your child's not a Kennedy Krieger patient, which is one of our program requirements, you can always call our intake line or do an online intake on our website, and we're more than happy to kind of send brief information, resources, referrals, things like that. And so if you have I saw some very specific situations, for people in other states, we often aren't going to provide kind of very specific legal advice because everything functions a little differently in every state, unless it's the question's a more general question. But we can get you hopefully pointed in the right direction with some general information and then kind of pointed to the right person. And then we have about, it looks like 2 minutes for questions. Dominique, would you like me to just pull questions from the chat? Would you like to read some?
I mean,
Well,
if something stuck out to you, please feel free, we probably have time for one or two questions. If not, I can pull, but if there's something you really want to answer, go for it.
sure. So somebody asked, is the prior, I think I'm going to pull a couple that are, I think, relevant to clarifying some of the things in the presentation. So one is the PWN, the prior written notice, part of the IEP or a separate document? It is here in Maryland, and generally it's going to be a separate document that is sent home. In our Maryland school districts, sometimes it's titled prior written notice, sometimes it's titled IEP team summary or team process review. There's all different names to it, but really after the meeting, you should be receiving something, and it should mention prior written notice and be structured in that format. If you're not sure, whether you've received it or not, I would first ask the team to send the prior written notice. You could just email it. And if they don't send you anything, or you're not sure if what they sent you is correct, you could reach out to the family support department for your local education agency, and the person who works there could definitely kind of let you know if it's the correct thing. Let's see, I'm just going through. So can a family ask for outside assessment to be reviewed and discussed in the prior written notice? Yes. So I would say that if there are, things in the prior written notice in the outside assessment, for example, a provider recommendation and the team is disagreeing with that recommendation, I would definitely ask for that disagreement to be documented in the prior written notice. So for example, if the outside provider suggests speech and language services and the IEP team is saying, yeah, we actually don't think the student needs school-based speech and language services, right? And here's why, I would say, please document that in the prior written notice. And then I always look at the PWN after the meeting to make sure it matches my notes, so that everything is accurately documented.